Sir, we'll start, sir. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Welcome to the Belaku lecture series being conducted by the Karnataka State Bar Council and the Karnataka State Bar Council Law Academy. This is the second lecture in the series being conducted by the Academy in the memory of some of the greatest personalities this profession had in the state of Karnataka, who continue to be a beacon of lights for the younger generation and the contemporary advocates alike. Today's seminar is in the memory of Sri M.S. Bhujangarao, one of the greatest lawyers the Karnataka state is proud of. Mr. Bhujangarao hailed from Madhugiri in Tumkur district, from my district. He was born in the year 1924. His father, Subramanya, was a government pleader. After his initial schooling, he moved to Maharaja College, Mysore for his degree and later to Kolhapur for his law. During his college days, Mr. M.S. Bhujangarao was an avid footballer and a sports person. He represented the college in football tournaments, including one in Ceylon, as the island nation Sri Lanka was then known. After completing his law from Kolhapur, Sri Rao taught English and history at Forts High School, Chamrajpet for several years. Mr. Bhujangarao was a promoter of arts and encouraged its development in all forms. Being a sports person, he also encouraged sports. He was associated with several educational and cultural associations such as the President of AV Educational Society, JP Nagar, Secretary of Model Education Society, Chamrajpet, and Vijaya College of Music, Jayanagar. Mr. Bhujangarao was a proficient lawyer in the civil, criminal, and appellate side of the higher and subordinate courts. He had gregarious personality and large circle of friends and admirers. He had affection for younger generation, younger members of the bar, and successfully mentored and guided many young advocates to establish themselves in the legal profession. He had the singular distinction of being the chairman of Karnataka State Bar Council, the president of Advocate Association, and also the president of Legal Practitioners Society. During his tenure as chairman of Bar Council, he had organized a conference at Glass House, Lalbagh, Bangalore, that was inaugurated by Srimati Indira Gandhi as the then Prime Minister. He, along with Mr. Ram Jethmalani and other stalwarts, played a leading role in the establishment of Law College, National Law School at Bangalore, resisting stiff opposition from several lawyers from the north. He is survived by a large family. His daughter, Srimati Manasa, is a practicing lawyer, and her husband and today's speaker, Mr. G.L. Vishwanath, is a designated senior advocate. The daughter, Dhriti, is also an advocate. It's a proud moment for the Karnataka State Bar Council to hear from the son-in-law of one of the greatest lawyers we had, Mr. M.S. Bhujangarao. And I'm particularly proud that he was also the chairman of Karnataka State Bar Council, to which I belong as the chairman of the Karnataka State Bar Council Law Academy. So I request Mr. G.L. Vishwanath to take over the session and to give his lecture on today's topic, Readiness and Willingness under the Specific Relief Act. Thank you, sir. Please take over.
Thank you, Mr. Basavaraj.
You can switch on the camera also, sir.
Yeah. It's on. Am I visible? Kanista idea? Thank you, Mr. Basavaraj. Thank you, Mr. Basavaraj.
Yes, sir.
I'm grateful to the Karnataka State Bar Council, the Karnataka State Bar Council Law Academy in general, and Mr. Basavaraj in particular, for visualizing and operationalizing a series of lectures based on the stalwarts of the bar and this being the second of such series, the first one being on Mr. Baira Reddy, and the one to follow thereafter on Mr. Retraju Naidu. Both Mr. Baira Reddy and Mr. Retraju Naidu were great friends of Mr. Bhujangrao, and it is just and proper that his lecture, memorial lecture, is sandwiched between his two friends. For him, friendship among the members of the bar was paramount. As many of the elder members of the bar would know, he was a gregarious personality, as Mr. Basavaraj just referred. He had a large circle of friends. And in those days that when Mr. Bhujangrao practiced, the bar was not as fractionalized as it is today, unfortunately. There was a lot of camaraderie, there was a lot of friendship, and everybody were in a state of great bonhomie amongst all members of the bar. In fact, the members of the bar and the members of the judiciary, many of them who had shifted over for being in the practice into the service, remained friends. They maintained distance, but they remained as friends on a very social level. Unfortunately, it is not like that now, and the bar is very fractionalized, unfortunately, for various reasons. Mr. Bhujangrao, my association with him was rather brief because I got married and then I left for Calcutta to take up employment in ITC. By the time I came back, I was with him for very few years before he passed on. But the fact that his memory lives on, and we are reminded about it by many friends and senior members of the bar, inspired me that I have, wedded into a good family and I have associated with a good person. Especially, he had a lot of affection for juniors. So if any juniors had any difficulty in any matter, he would readily tell them, Yako worry madkotya, ellide case hedu nane bartini anta. He would immediately drop his work, didn't need to read the brief or any of the papers, would go to the court and immediately argue the matter on behalf of that junior. Similarly, in court, if he found any of the judges riding roughshod over the juniors, he would stand up for them and tell the judge, you must give them an opportunity to read the papers and come back. Please don't ride roughshod over them and see that their morale comes down. And that is the way in which he encouraged and maintained an equilibrium among the members of the bar and the judiciary. He has a large family, as he said, and there is a weight of expectation on this lecture that I'm going to deliver today. And I am grateful once again to the Bar Council and the Law Academy for having given me this opportunity to express myself. Mr. Bhujangrao also encouraged juniors to participate in law conferences and seminars, both within the state and outside. Many times he would, give bus charge or train fare for the juniors to go outside and attend these conferences, so that more for the experience and mingling with other members of the bar from other states, so that they could get an experience of how it was. Many of the juniors would never have traveled outside Bangalore or outside their state. It was an opportunity to meet lawyers from other places and see how they function and what is the practice that is there. So with these few prefatory words about my senior, I would request, with the permission of Mr. Basavaraj, to proceed into the topic. This talk on readiness and willingness under Specific Relief Act was actually scheduled for last week. Mr. Basavaraj called me. In fact, ever since this series of programs were visualized by Mr. Basavaraj, and ever since my designation, I was being asked by Mr. Basavaraj to talk on any topic of my choice. But you know how lawyers are, it becomes difficult for us to choose a topic of our own. So I kept postponing till it came to the stage and push came to shove. And Mr. Basavaraj said, you speak on readiness and willingness under Specific Relief Act in the light of the new amendment, sir, it will be nice. We'll have it as a memorial lecture in the name of your late senior, and therefore here I am. In fact, this program was to have been held last week. I was willing, but I was not ready, and therefore I sought for a week's time. And in the meantime, Mr. Basavaraj spoke on the basic structure of the Constitution as expounded in Keshwananda Bharati last week. And those are very big footsteps to follow as far as Mr. Basavaraj's talk is concerned. But I will make my own small little effort to give the audience today an overview of the Specific Relief Act and the amendments that have been brought in, and the concept of readiness and willingness, which has given rise to a lot of litigation. In fact, hundreds and thousands of cases on Specific Relief Act, readiness and willingness that the courts have dealt with. As many of you know, specific performance is an equitable remedy that enforces the promisor to do the duty that he promised to do. This is in contrast and contradistinction to providing pecuniary compensation by way of damages for non-performance. In old English courts of the mid-19th century, there was no provision for granting specific performance. The only remedy that lied was to grant damages if the contract was breached. But the equity courts of the Chancellor, they had a provision to award relief over and above and outside of damages, and therefore this concept of specific performance evolved around the late 19th century. The earliest model of the Specific Relief Act in Indian law is the Specific Relief Act of 1877, which is based on the model of the New York Civil Code of 1862. Subsequently, the Act was amended, and the present Act of 1963, the Specific Relief Act of 1963, is the one that is now currently in force. Now, under the present Specific Relief Act, as it stood prior to the 2018 amendment, the rule was specific performance, the damages was the rule, and granting specific performance in respect of a contract was the discretion that was vested in the court under Section 16. But this gave rise to a lot of difficulties in implementation, because with the advancement of India as a signatory to many international agreements and the development of trade and law, many of the agreements that were being entered into were not being adhered to by the parties who were witness or parties to that agreement. Therefore, how to implement or how to change the law so that agreements are enforceable and become enforceable and not merely a claim for damages, a committee was constituted by the central government to examine and suggest changes to the Specific Relief Act of 1963 to keep pace with the changing business dynamics and to facilitate enforcement of contracts and for speedy settlements. As many of you know, suits for specific performance takes years together in the court of first instance. Then they are appealed against. If the valuation is more and it comes before a division bench, our experience in Karnataka at least has been that it takes 10 years for a first appeal to be decided. And by the time the matter goes to Supreme Court, you have willy-nilly spent about 15 to 20 years. At that stage, if specific performance were to be ordered on the basis of the agreement and prices that were prevalent 15 years back, it is great injustice to both the parties. Therefore, an amendment was brought about to the Specific Relief Act with effect from 1st of October 2018 to change the approach insofar as granting of specific performance, making it the rule, and awarding of damages as being an exception. This is not the situation as it was prior to the amendment. It was the exact vice versa. The Amendment Act also brought about a stipulation that the suit for specific performance should be decided within a limit of 1 year plus 6 months, like a grace time for disposal of cases. I will just point out to you what are the important changes between the unamended Act of 1963 and the amendments that were brought about by the 2018 amendment with effect from. The first important change that was brought about was with respect to Section 10. The discretion that was vested in the court under Section 10 to grant or refuse specific performance was substituted by the word shall under Section 10. Therefore, this element of discretion to award or not to award specific performance was removed and made mandatory under Section 10, thereby bringing about a shift or a change in the stand that specific performance to be awarded was the rule and damages constituting an exception. Then under Section 16 of the unamended Act, the plaintiff was required to aver, that is to plead and to prove regarding his readiness and willingness. The word aver or plead was removed under the amended Act, and it was sufficient for the plaintiff to prove that he was ready and willing to perform his obligations under the agreement. What is the nature of that readiness and willingness? At what stage it was required to be established? Was it throughout, or was it only prior to the date of the suit? That we will come to in the next few slides that I'm going to talk about. Then under Section 20 of the old Act, the unamended Act, there was a discretion to the court to grant or refuse the relief of specific performance. For instance, if the contract, if awarded in favor of the plaintiff, would give an unfair advantage, or it would involve certain hardship as far as the defendant was concerned, or it was otherwise inequitable to grant this relief. So just see, each of these words, unfair advantage, hardship, and inequity, were all in the realm of discretion that was vested in the court to grant or not to grant specific performance. And the courts also, under Section 20, had certain other guiding principles, that mere inadequacy of consideration or the onerousness or the alteration of position by one of the parties was to be considered as a factor. Now, as far as inadequacy of consideration is concerned, many agreements, as I was pointing out earlier, were entered into at a point of time when inflation was not very prevalent or very volatile, and the prices of properties were more or less constant. But with the passage of time, especially with respect to urban properties, as many of you are aware, urban properties value has gone up exponentially. Now, to expect a party who has entered into an agreement to sell an urban property at a particular price and to stick to that price, because inadequacy of consideration was not a ground for denying specific performance. If the defendant seller is made to stand by that promise and see to it that he sells it at the same price insofar as urban properties are concerned, this would cause great injustice. The seller had entered into an agreement to sell a particular property for various reasons. It may be grounds of impecuniosity, it may be on grounds that he wanted it for marriage expenses of a child, it may be to meet medical emergencies. Now, therefore, a short period of time was given for performance of the contract. But the defendant, but under Article 54 of the Limitation Act, many of you are aware, what is the period of limitation that is prescribed for enforcing a contract for specific performance. It is either 3 years from the date fixed for performance, or if no period is fixed under Article 54, then when refusal is made known to the plaintiff that the defendant is not going to act in accordance with the terms of the contract. Either way, the plaintiff had 3 years plus the period fixed under the agreement to file a suit for specific performance. There are many cases, many of which many of you are aware, where the suits for specific performance would be filed shortly before expiry of the period of limitation, maybe a day or two before limitation expires, or they would wait till such time that the defendant is tired out and he goes and sells the property to somebody else, then they would file a suit for specific performance. Therefore, all these considerations weighed in the mind of the court to grant or not to grant relief under the unamended act under section 20. Now, under the 2018 amendment, the time limit has been fixed, namely 12 months plus 6 months grace period for disposal. There is a new provision, section 20, regarding substituted performance that has been introduced. And importantly, section 20 capital A has been introduced under the Specific Relief Act amendment, which says there are certain categories of projects called infrastructure projects. Now, these nature of infrastructure projects are, just give me a minute, I'll just tell you. They are like transport. Categories of infrastructure projects are transport, roads and bridges, shipyards, ports, inland waterways, airports, railway tracks, energy, electricity generation, oil pipeline, gas pipeline, water and sanitation, solid waste management, communications, telecommunications, towers, educational institutions, and social and commercial infrastructure like sports infrastructure, hospitals, tourism, terminal markets, soil testing, affordable housing, etc. Now, in respect of these definition of projects under section 20A, read with the schedule, they are called infrastructure projects. In respect of infrastructure projects, the Amendment Act says no injunction shall be granted under section 41HA. Therefore, you see in the delay in disposal of cases relating to specific performance also arises largely because some injunction is obtained, the matter goes on. There is a mini trial that goes on as far as injunctions are concerned. The disposal of the suit on merits gets held up. And therefore, to prevent this from happening insofar as infrastructure projects are concerned, the courts have said no injunction in respect of infrastructure projects under section 41HA. Now, the question is, this Amendment Act came into effect from 1st of October 2018. Certain substantial changes have been brought about in the Amendment Act. Question is the Amendment Act a prospective or is it retrospective? The Supreme Court had occasion to consider the effect of this amendment in the judgment that has just been shared on the screen. And the Supreme Court said that the amendments brought about by the 2018 Amendment Act is not merely procedural, rather it is substantive in nature and therefore it would not have retrospective applicability. It observed that ordinarily the effect of the amendment by substitution would be that the earlier provisions would be repealed and the amended provisions would be enacted in place of the earlier provisions. However, if the substituted provisions contain any substantive provisions which creates new rights or obligations or takes away any vested right, then such substitution cannot automatically be assumed to have come into force retrospectively. In such cases, legislature has to expressly provide whether such substitution is to be construed retrospectively or not. Therefore, general position in law that amendments to substantive law do not apply to pending proceedings and apply only prospectively, while amendments to procedural law can apply to pending proceedings. Therefore, in view of this decision of the Supreme Court 2022 decision, the benefit of the amended act will not be available for parties if the transaction took place prior to the date of the amendment, that is 1/10/2018. Therefore, it is only prospective in nature and not retrospective. This brings us to the main subject of today's lecture, what is meant by readiness and what is meant by willingness. Readiness, they say, is a state, readiness means to perform the contract and the capacity of the plaintiff to perform the contract, which includes his financial position to pay. So readiness, in other words, is the preparedness to fulfill his obligations when the time for performance arises. Am I in a state of preparedness to do what I am required to do as per the terms of the contract? Now, all of you are aware that in every contract, there are reciprocal obligations and responsibilities of both parties. For instance, as far as the plaintiff is concerned, in a suit for specific performance, the obligation of the plaintiff is to be ready to pay the balance sale consideration to the defendant within the time stipulated under the contract and to obtain the sale deed from the defendant. The obligation of the defendant may be manifold. For instance, the property may be tenanted. I'm just giving you an example. There may be a provision under the contract that the defendant will obtain vacant possession of the property and then hand over vacant possession to the plaintiff before actual execution of the sale deed. Or there may be a situation where the property is purchased as is where is. That means there is atonement of tenancy in favor of the plaintiff. So the obligation to provide vacant possession may or may not be one of the may possibly be one of the conditions that requires to be performed with the defendant. Secondly, defendant may have placed the property in mortgage or otherwise encumbered the property in favor of some bank or financial institution. That will have to be redeemed before the sale is to take place. Or that may also be one of the conditions under be purchased along with the encumbrance. Thirdly, let us say that this is a case of the defendant having only part interest in the property. For instance, let us say the defendant is a part of a joint family and he agrees to get the signature of the other brothers or other members of the co-partnership before the sale is actually effected. Then one of the conditions or obligations to be performed by the defendant would be that he will get the signature of the other members before the sale is actually effected. So each person under a contract is required to perform certain obligations, reciprocal obligations. In reciprocal obligations also, it may be contemporaneous, it may be one before the other. We'll not get into all that at this stage. But as far as the plaintiff is concerned, he should be physically ready to perform what he had contracted to perform, whatever it be. That's why it doesn't say whether he should do this or that. Whatever he had agreed to do under the contract, he should be in a state of preparedness to do that. That is a physical manifestation of intent, means readiness. And invariably, readiness must be backed by willingness. Now, willingness means a mental process. It is the willingness to perform a contract is to be ascertained from the conduct of a party. Now, in many cases, it happens that plaintiff, obviously in a suit for specific performance, will have to be ready to pay the balance amount to the defendant when the time arises or within the period that is specified under the contract. Now, he may not have the money, he need not have the money with him to show it to the court, but he should be in a position to raise that finance, the capacity to raise that finance when the time comes. Therefore, these are all aspects of readiness and willingness on the part of a person for the court to consider whether specific performance should be granted or should not be granted. So this readiness and willingness has three components. Can you just come back to the previous slide? So there are three components of this. That is a conduct of the parties, the readiness of the parties, and the financial capacity. I'll just go into each of these briefly. In conduct of the parties, the conduct of the plaintiff must be judged with regard to the entirety of the pleadings and evidence brought on record And just a mere averment is not sufficient. It needs to be determined with regard to the attending circumstances. So when the court, when it is considering whether a plaintiff is or is not ready and willing, it is not a single event that has to be looked into, but the entire circumstances have to be looked into to find out whether he was or he was not ready. And this conduct of the plaintiff is to be judged as to how it was prior to the date of the contract. I mean, when the period of contract was stipulated, the date between the time fixed for performance and the date of filing of the suit, and from the time of filing of the suit till the time that the court ultimately adjudicates the matter. Let me give you an example of that. For instance, let us say that there is a sale agreement specifying a period of 6 months. Now, within that period of 6 months, the defendant may have had to do many obligations. For instance, he may have to give encumbrance certificate. He may have had to give copies of the documents of title. He may have to give some public notice was given by the plaintiff under the instructions of the under the advice of the defendant. Some third party has given an objection to that. Those objections are forwarded to the defendant for compliance. The defendant has to see that those objections are removed as far as the property is concerned, so that the property is in a state of non-encumbrance for it to be sold to the plaintiff. Now, as far as the plaintiff is concerned, let us say that there are no objections. All that he needs to show is to the defendant that he is ready and willing to perform. Therefore, within that period of 6 months that is prescribed, he will issue notice to the defendant and say, look, I have the money with me. I have sent you a copy of the draft sale deed. You look at the draft sale deed and fix a time that we can go before the sub-registrar. He also gives him a copy of the sale deed with corrections and says, or let us say the defendant sends a copy of the sale deed, he corrects it, sends it back. A time is fixed for performance. The plaintiff goes before the sub-registrar, but on that appointed date, the defendant does not appear. Therefore, this conduct of the plaintiff in having exchanged a draft sale deed, gone to the sub-registrar office also, brings about a situation where plaintiff can be said to have exhibited or manifested his preparedness to perform his obligations under the contract. Therefore, it could be said that he was ready, and the fact that he came before the sub-registrar means that he was willing also. Nobody would appear before the sub-registrar unless he had the money to pay the balance in consideration. So, what is the conduct of the plaintiff? And unblemished conduct must be there throughout the period that is fixed for performance and right up to the time when the suit is ultimately to be decided. And what are the nature of the pleadings that have to be put into the plaint as far as the readiness and willingness is concerned? There is no straitjacket formula. There is no specific phraseology or language. Many times in the earlier, before the amendment of 2018, the words ready has been ready and willing and continues to be ready and willing, like a mantra, like a ceremony. You would have to mention that in the plaint. Of course, that has now been removed under the 2018 amendment. But in substance, it must be mentioned, but which could also be inferred from conduct, that the plaintiff was ready and willing to perform whatever obligations had been enjoined on him under the agreement. Lastly, the question is, what is the nature of the evidence that has to be produced to show that the plaintiff was willing to perform his part of the contract? I have given you some examples earlier, that let us say that within the time that is stipulated, he has given a letter saying that I am willing to do it, or please give me details of your bank account to which the balance consideration can be said, or if TDS is to be deducted on the balance amount that has to be paid, he deducts the TDS and remits it to the authorities. That shows that he is interested in taking this transaction to the next level or to the next stage. Or he exchanges a copy of the sale deed, draft sale deed, or he some documents are to be procured and sent by the defendant to perfect his title, maybe an encumbrance certificate, maybe a no due certificate from a housing society, if that is respect of some land that belongs to a society, or something like that. And if the defendant doesn't do it, the plaintiff himself goes to this authority and obtains these documents. These are all circumstances which will show that he has objectively communicated and given notice to the defendant about his willingness to perform during the time fixed for performance. Of course, at each stage, I have pointed out some judgments, leading judgments on the point. Then we come to the question of readiness. Plaintiff has to prove continuous readiness and willingness at all times, from the time of the contract till the suit and up to the decree. This is the classic case, the famous cases of Gomati Nayagam Pillai of 1967 of the Supreme Court. Then we come to the issue whether time is the essence of the contract in contracts relating to immovable property. The Constitutional Bench judgment of Chandrani in 1993 says that in respect of contracts relating to immovable property, the rule is that time is not of essence. Now, if you say that time is not of essence in a contract for immobile property, then the question will arise, what is the sanctity or significance to be placed, or what is the value to be attached to the period that is fixed under the agreement? Now, in every agreement, there will be some period that is fixed. It has, performance has to be done in 2 months, 3 months, 6 months, 1 year, something will be mentioned. Or if no time is mentioned, then under the second part of Article 54, when performance is refused by the defendant. But if there is a time limit that is specified for the parties to perform their obligations under an agreement, what is the value to be attached to that time limit? In fact, in Chandrani itself, the Constitution Bench says, having said that time is of the essence in a contract for sale, not of essence in a sale for contract, time not being of essence in contracts for the sale of immovable property, they also say that you cannot completely ignore and disregard the time limit that is fixed under the agreement for performance of obligations. As I pointed out earlier, in many agreements, the reasons as to why the defendant wanted to sell that property is a factor that has to be considered. For instance, the defendant may have wanted to sell the property to recover or to realize money for a medical treatment, for the performance of a marriage, or to perform some other obligation for which the money was required. And if the plaintiff does not give him the balance amount within the period that is fixed, the defendant unfortunately cannot automatically terminate the agreement and sell it off to somebody else, because Article 54 permits that the limitation period is 3 years for that. Therefore, this time limit that is prescribed under the agreement has to be given its due value, notwithstanding the judgment of Chandrani saying that time is not of essence. Now, this has been what is the significance as far as time specified in an agreement that has been dealt with very beautifully in this 1997 judgment of Vidyanandam versus Vairavan, where they say that, I'll just point out, it cannot be said that any and every suit for specific performance of which does not specifically provide the time should be the essence of the contract. It cannot be said that all those suits should be decreed, provided they have been filed within the period of limitation, notwithstanding the time limit stipulated under the agreement for doing one or the other thing by the other party. That would amount to saying that time limit prescribed by the parties in the agreement have no significance or value, and that they mean nothing. The rigor of the rule evolved by the courts is that time is not the essence in case of immovable properties, and this rule was evolved in times when prices and values were stable and inflation was unknown. In case of urban immobile properties, it is high time that the court recognizes that the rising prices are something that have to be taken into consideration, and the time limits cannot be ignored altogether on the ground that it has not been made the essence of the contract, but some significance will have. So therefore, in respect of the time limit that is prescribed between the parties in an agreement of sale relating to urban immobile property, the period that is prescribed will have to be adhered to, and there will be greater scrutiny to find out if the defendant, the plaintiff has performed his obligations under that. Otherwise, as I pointed out earlier, in the trial court, the suit will go on for 5 years, in the appeal court, it will be 10 years, and the Supreme Court will take on. By that time, after 15 years, if the defendant is obliged to sell the property to the plaintiff at the same price on the date of the agreement, that would cause great injustice, in at least insofar as immobile properties are concerned. Therefore, this concept of time not being of essence in a contract for the sale of immobile property will have to be delicately balanced against the significance of time that is prescribed under the agreement and the offset of any price escalation that may take place. Therefore, these are the factors that will have to be considered by the court. Lastly, many times it happens that in a suit for specific performance, the party would have, the defendant may have sold the property to a third party purchaser, either during the pendency of the suit or immediately after the period that was prescribed. The plaintiff not coming forward, he would have sold it. So either in case of a pendente lite transferee or a transferee from a defendant prior to the date of institution of the suit, all defenses that are available to the original agreement holder are also defenses that are, all defenses that are available to the defendant are also available to the subsequent purchaser. This is what Ram Awad says in 2000. And of course, here, this is admitted the Supreme Court is based on previous decisions of
Sir, I think you exited? There is some technical problem. Kindly wait. Yeah, please, sir.
sorry.
Now you can share, sir. Now you can share. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Sorry, I
It's
think
okay, sir. It's okay. It's okay.
there was some technical glitch.
Yes, sir. Yes, sir.
Whoever is ready and willing, unless technology permits us, nothing can be done.
There's a good strength, sir, today. Good
So,
strength.
so what I was saying was that the defense of lack of readiness and willingness is a defense that is available to the defendant in a suit for specific performance, and to the alienees of the defendant is the legal position. Now we come to financial capacity. Now in financial capacity, of course, all of you know that there is no need or requirement to jingle the money in the pocket. All that you have to have is the capacity to pay that you have to establish. Now, for instance, let us say that there is a suit for specific performance. I'm just using it in a loose terminology. Let us say a suit for specific performance filed by Vijay Mallya. I mean, or let's say some other, let's say Tatas or Birlas or something. It doesn't mean that just because they have filed it, they don't have to establish. The standard and degree of proof that will have to be given by them will be far less than any other ordinary plaintiff. But not that the money has to be put on the table. The capacity to pay or the capacity to realize or ability to raise that money is the factor that will have to be satisfied to the satisfaction. I mean, will have to be proved to the satisfaction of the court. Then without such a plea being made and without from material being produced, the court cannot accept that financial capacity of the plaintiff is there. Let me give you an example. For instance, there was a suit for specific performance that was filed in respect of a property, I think in Coimbatore or somewhere, in which the substantial part of the sale consideration had been paid upfront at the time of the agreement. Balance amount was not paid. Subsequently, plaintiff filed a suit for specific performance. Defendant, of course, took various defenses, saying that that you are not really ready and willing, etc., etc. The suit was decreed by the trial court. In appeal, it was the decree passed by the trial court was confirmed. Matter went up to Supreme Court. So there was concurrent finding of two courts regarding decree of the suit, holding that the plaintiff was ready and willing. In the Supreme Court, after examination of the records, it was found that the material that was produced by the plaintiff to show financial capacity was certain income tax returns. Those income tax returns related to the period post the agreement, I mean, post the filing of the suit. Therefore, on examination of that, they said, during the period that was fixed for performance of the agreement, that is from the date of the agreement till the date of institution of the suit, this fellow was not an SSE. The plaintiff was not an SSE. Therefore, it could not be held based on the income tax returns obtained after the filing of the suit that he was ready and willing to perform. So therefore, material must be produced to substantiate that you have the financial capacity to pay the balance sale consideration. What about the T? Okay. Then there are some general principles. These are some of the general principles relating to suits for specific performance. First one is, what is the appropriate relief that is to be claimed in a suit for specific performance? There is one judgment of the Supreme Court which says that prior to the institution of the suit, let us say the plaintiff has not exhibited readiness and willingness within the time that is stipulated under the agreement. And on the expiry of that period before the suit is filed, the defendant issues notice terminating the agreement. Later on, Suit is filed for specific performance. Question is, since the contract itself has been terminated by the defendant, whether there is necessity to ask for that termination to be set aside before suing for specific performance, or whether the suit for specific performance is maintainable. There is one judgment of the Supreme Court in Sikandar which says that if you don't ask for setting aside of that termination, then the suit is not maintainable. So therefore, one of the appropriate reliefs would be to ask for the relief of termination being set aside before suing for specific performance. Then Section 22 of the Act says that in a suit for specific performance, if you don't ask for a particular relief, that relief cannot be claimed or the relief cannot be granted. For instance, recovery of possession or for partition. Partition, the example is that you are buying an undivided interest in a property from a co-parcenary or joint holders of property. They may be co-owners of property, you are buying one person's share. Unless you ask for the relief of partition to carve out the share of the person whom you are purchasing, you can't be granted that relief, or even for refund of the advance that has been paid under the agreement. Specific relief will have to be asked. This is the appropriate relief that will have to be given. Then next, who are the necessary parties in a suit for specific performance? Section 19 of the Act stipulates who are the persons who are proper and necessary parties and against whom it can be enforced. And question is whether a subsequent purchaser with or without notice of the contract, but who claims adversely to the claim of the vendor, he will have to be made a party. And the tests for finding out whether a person is a proper or a necessary party is the same tests that are applied under Order 1, Rule 10 to find out whether a person is a proper and necessary party, namely that without that person no effective relief can be granted, or in the absence of that person no effective decree can be granted. These are the two tests to find out who are necessary parties to a suit for specific performance. And of course, this is the classic and important case, leading case on the point, Kasturi versus Ayam Perumal, 2005, 6 SEC 733. And one second, let's go back. And then the Supreme Court has, of course, expounded on the question whether a person who purchases the property from the defendant prior to the institution of the suit, whether he is a necessary party, and whether he is a necessary party, A. B. Whether a pendenti lite transferee is a necessary party. 3. At whose instance the application is made is also important. If the application is made at the instance of a person who is a pendenti lite transferee, how it is to be dealt with. If the application to implead a subsequent purchaser as a defendant is made by the plaintiff, what is the effect of that? If an application to implead a person who has purchased the property prior to the date of the suit, but came to the knowledge of the plaintiff after the institution of the suit, how is it to be dealt with? These are all instances that the Supreme Court has dealt with. But the long and short of it is that persons who have an interest in because you see in a specific performance suit, once the defendant has sold the property, he has no longer any interest in the subject matter of the suit. There is no effective defense to the plaintiff except by the subsequent purchaser or by a purchaser who has purchased it prior to the date of institution suit. Therefore, somebody has to be there to defend that proceeding. Therefore, those persons have to be brought on record. Otherwise, it will be a one-sided a match for which there is no contest at all. And tomorrow, the person who is actually affected by it will come back to set this whole decree at naught, saying that I was not made a party, I was not heard, because obviously transfer of interest in immovable property would be by a registered instrument. And that registered instrument would be to the knowledge of the plaintiff, because under Section 3 of the explanation of Transfer of Property Act, which says that person is deemed to have notice of a fact when a document is registered. Therefore, it is also lies upon the plaintiff to make enquiries as to what the nature of the property has been dealt with, and to make the persons as parties to the proceedings. And therefore, the upshot of this whole thing is that third-party strangers who have no interest in in the property under dispute, they are not to be made parties to the suit. Then the other general principles of law that have been enunciated in various decisions of the Supreme Court is what is the proper form of decree that is to be passed in a suit for specific performance, where let us say that the pendent in lite transferee is also there. In Durga Prasad, the Supreme Court says that the transferee pendent in lite should also join in the execution of the sale deed between the vendor and prior transferee, so that proper title passes to the plaintiff. Otherwise, you will have a situation where there are two conflicting sale deeds. One, a sale deed in respect of which suit has the court has granted a decree for specific performance, and on the other side, the principle will be that the pendent in lite transferee sale deed is also there. Then, what is the limitation that is prescribed for filing a suit for specific performance? Article 54 says, leave it. Article 54 says 3 years from the date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that the performance is refused by the defendant. So two different components of Article 54 which prescribe the limitation. Of course, you go back to Chandrani, which says that time is not of the essence of a contract in a contract for sale of immobile property. Contradistinct with Vidyavannam, which says that the time that is specified for performance under a contract also has to be looked into. Then Section 28 of the Specific Relief Act says that a court passing a decree retains control over the property even after from being rendered futile. For instance, let me give you an example. A time limit is given for payment of the balance sale consideration and for execution of the sale deed. Within that time that is specified, the plaintiff does not deposit the balance sale consideration. Then what happens to the decree? Does the decree remain for all times to come because no appeal is filed against the decree? In such a situation under 28, defendant can approach the court and say, since the plaintiff has not deposited the thing, let the decree be rendered ineffective so that the defendant is free to sell the property. One situation where court exercises power even after the decree is passed. The other situation is where the plaintiff is required to deposit the balance sale consideration within a specified period. And within that period, he is unable to do it. Therefore, he asks for permission to extend the time that is fixed for performance. 3, where one of the parties dies after the passing of the decree for which no appeal is filed. For instance, let us say that the plaintiff obtains a decree for specific performance, the defendant has died. Now the LRs have to execute it. Therefore, an application is filed under 28 to substitute the defendant with the names of the LRs so that the decree that is passed in respect of the deceased defendant will now reflect the names of the LRs. The last provision regarding this is that in respect of an agreement to sell, which contains a recital regarding delivery of possession, such a kind of agreement is required to be registered compulsorily. The amendments have been brought about to both the Registration Act, Section 19(1)(a), and to Section 53 of the Transfer of Property Act from 2001. So an agreement of sale containing a recital of delivery of possession but unregistered is not something that the court could take cognizance of. So I think this brings us to the end of today's brief lecture on the subject. And once again, I'm really grateful to Mr. Basavaraj, the Bar Council and the Law Academy for having given me this opportunity to share a few thoughts on the subject.
So thank you, sir. That's not only an excellent speech on the subject, but it's the complete justice done to the to one of the greatest legends of the Karnataka advocates fraternity, Sri M.S. Bhujangrao. So now I'll open the question and answer session. See, others can also join, unmute themselves and ask the questions. Let me stop the recording.